Okay, yeah, all right. All right, assalamu alaikum. Welcome to you all. I'm going to start with a acknowledgement to country, and I want to acknowledge that I'm coming to you from the lands of the Dowry people and pay our respects to elders past and present, and from wherever you are joining us today as well, to those who are continuing the story. Welcome to the very first webinar that covers such a sensitive topic for many, but at the same time such an important topic for us all. So there are a couple of things we want to go through, and this is the boring stuff, so please bear with me. I've been assigned conveyor of boring information. So for those who are just joining us now, we wanted to let you know that the participant chat is open and ready for you to engage. We do encourage engagement, inshallah. You do have the option to change your name and rename if you wish to remain anonymous, so we would encourage you to do that. Throughout the course of this webinar, inshallah, you will have the opportunity to submit your questions via the chat, but be mindful that the chat is visible to others as well. So there are a couple of things that we do require from the outset, and that's just to make sure that we are, receiving this information, benefiting, inshallah, from this information, and also protecting others who may be joining. So when you're submitting your questions, please refrain from adding sort of specific detail that might reveal names and circumstances and situations of others. That's really important in the context of this space we're working in. The other thing is, please be mindful that any information that is shared this evening is general in nature and does not constitute legal advice. You do have options, and it is recommended that you seek legal advice and financial advice where necessary and applicable, and Sister Tasnim will take you through that information. But just be mindful that this is all general information. The good news is it is tailored. It is tailored to your needs, for whether in your situation you're separated, separating, divorced. This webinar has been designed, this information session is designed to address some of those, red flags, green flags, issues and information that you really need, that you may not have considered. And let's be real. Many people don't in this situation. So without further delay, those are our little housekeeping boring things. I'm going to now do the formal introductions. I'm Soumaya Najjarin, so I'm the Director of New Beginnings Australia. For those of you who aren't familiar with our humble little not-for-profit organisation, we were established 3 years ago now to fill a critical gap in divorce recovery support services for Australian Muslims. And what we discovered along the way through our data collecting and extensive consultation with stakeholders nationally is that there's a common denominator in this space, and it's that everybody who experiences separation and divorce is impacted emotionally, mentally, financially, legally, and it encapsulates so many areas that sometimes that can be so overwhelming for individuals to process. And while we're in that emotional turmoil and trying to sort of navigate, well, what happens to the kids and the legal and the finances, if finances are there, sometimes we overlook things like, what happens when I die? What happens to my kids? Who's going to look after what? So this is why Muslim Wills and New Beginnings have come together. We deliver peer support. Our flagship program is a peer support program, Recover, Rebuild and Flourish. We also deliver in collaboration and separately a lot of sort of human-to-human connection initiatives to address the lack of that disconnection that some individuals feel, and that lack of sort of belonging after divorce. That's New Beginnings, and welcome to you all. Thank you all for giving us your time and lending us your attention this evening. Muslim Wills. So Muslim Wills is a wonderful new bespoke platform, and Muslim Wills is designed specifically to to promote sustainable, structured and impactful philanthropy in Australia. So Muslim Wills is funded by Awqaf Australia, and the whole idea around Muslim Wills is that it's here to help guide Muslims through secure, Islamically compliant estate planning to ensure a future aligned with Islamic values for their loved ones. So the Muslim Wills, the product Muslim Wills has been developed with Australian lawyers and it's been reviewed by barristers. They've got the Islamic professors. All of the consultation has been done to guarantee that, inshallah, to ensure that it's a robust system to help you create some legally valid wills. What we'll do next is, I think we're looking at the time. I can still see some people coming in, which is fantastic. I'm going to introduce our main event this evening, and we want this to be thorough, informative, and we want to make sure that we're using all of this time to give you the information that you came here for. I will note though, if any of this seems a little bit overwhelming or there's too much information, two things are going to happen, two things that will assist you this evening. One, you will receive a recording of this webinar at the end of it, inshallah. And two, there are many resources that Muslim Wills have already developed on the website that are also available, and we're going to link all of that together, bundle it all up together and send it to you as a resource, inshallah, at the end of this webinar. All of the questions that are submitted, we will try to get through as many as possible. And for those that we can't get to this evening, we're happy to go away, have a look at them and see what we can come up with in the way of sort of like an FAQ or general answers. All right, Tasnim Saeid introducing. Tasnim is a solicitor and I'm reading off a script because I got to get the intro right. Nationally accredited mediator and legal counsel at Awqaf Australia. So Tasnim has over a decade of experience in family law, estate planning and the not-for-profit sector, which makes her perfect for this evening. And you'll find out why soon. Tasnim holds a Masters of Laws, specialising in family law and dispute resolution. Her expertise spans Islamically and legally valid wills and estate planning for divorced and separated individuals. Without further delay, welcome Tasnim. Over to you. The floor is yours.
Jazakallah khair. Thank you so much, Soumaya. Assalamu alaikum, everyone, and thank you so much for joining us this evening. I really appreciate everybody taking out the time on a very cold Friday afternoon or evening, I should say. But inshallah, today's session would be of use to you. As Soumaya said, we are going to cover some heavy content, and it is a content-heavy topic. If you feel quite overwhelmed or you feel like there's a lot going on, it's not you, it is the topic and it's the nature of what we're discussing. So to ease you into making informed decisions and thinking about your family dynamics in the best way possible, as Soumaya correctly pointed out, inshallah, we will hold your hand after this session by way of resources and further assistance where required. And I also just want to acknowledge at the beginning that the content I am going to cover is of a sensitive nature and may bring some, I guess, trauma back for some individuals, given what people's experiences may have been. So if you feel like you need to take a break or just stop or take out some time for yourself, please feel free to do so, as this session is being recorded and you can always come back to it as a resource, inshallah. So let's get started. What we'll cover today is Islamic estate planning for separated couples. So I am going to be touching on two primary areas of law. One is estate planning and the other is family law, with a focus on the convergence between the two systems. Those two systems or spheres are also under the broader umbrella of the Islamic practice or Islamic jurisprudence, as this seminar is targeted towards Muslims who wish to have their values and their beliefs as Muslims honored in making informed decisions about their family, whether in the end-of-life space or in the family law space. So what we'll cover today is just a very brief overview of the two legal systems, Australian and Islamic inheritance systems, why estate planning is needed, an overview of the distribution according to Islamic law, who inherits, who doesn't inherit Islamically, so you're able to understand the landscape to be able to make informed decisions about your family. And then the convergence. So divorce and separation, what is the impact of that on your estate? Practical issues at death, child guardian nominations, Mahr, trusts, what your will must cover, and Wasiyyah. And inshallah, I'll just quickly also touch on Muslim wills as a product. As Soumaya said, it's a bespoke platform developed to allow Muslims to have a legally binding and Islamically compliant will. So if you feel like the content is, okay, well, this is a lot, how do I make it happen? Alhamdulillah, we do have the solution, which is Muslim wills, and we can have a chat about that also. So let's get started. What is the, or what I should say, what are the two systems and what is the landscape we're operating in? Under Australian law, when we're talking about estates and estate distribution, you have the freedom to leave assets to anyone with no mandatory shares. There's no concept of preset shares or somebody has to inherit from you. That's the keystone or key principle in the secular Australian law that we have. Spouse and children can challenge via what we call family provision claims. So the estate is not free from challenge or an arbitrary decision by someone who is not yourself, which can be a judge if a family provision claim is made. A final divorce order revokes gifts to former spouses, but not the will altogether. Separation has no effect on a will until a divorce is finalized. This is a key point. If you don't remember anything from today, this is what you really need to remember. If you and your spouse are separated, whether living under the same roof, whether living in different houses, but the divorce has not been issued, a divorce order through the court, you are operating in like a hybrid limbo system in which, for all intents and purposes, your spouse retains, or your separated spouse retains, a lot of legal rights, which I'll cover. And it's very, very important that if you don't want this to continue, for you to put a stop to that. And I'll explain in a second. You need to understand that superannuation and insurances sit outside of the estate planning sphere. They have their own binding nominations and own processes. And joint tenancy, so if you have a house that you own with your partner, even if you're separated and you pass away, if it's owned as joint tenants, the surviving partner has the right of survivorship, meaning that they actually do receive the entire estate after your passing, unless you do something about it. We'll touch on each one of these topics in due course, but at a glance, that's why this topic is so important, because we're touching on really where the money is at. So where are your assets? Where's the money at? We're talking about, your house, your super. For most people, that's your two most significant assets after, most significant assets, followed by things like car, jewelry, and things like that, okay? Islamic system is completely different. Islamic system, you've got fixed shares known as fara'id, which can't be changed or waived. So if you want an Islamic estate planning solution that you actually want to follow the Islamic guidance, it's actually fixed shares. You have a discretionary component capped at 1/3 of your estate. Final talaq or khulu' can terminate spousal inheritance under the fixed shares that I spoke about. However, a revocable talaq, the spouse may continue to actually retain inheritance rights, especially during the iddah period. For those who are not familiar with the way Islamic divorce works, is you've got three utterances of divorce, which are revocable, so the person can come back and be the person's wife. And then you've got a final or irrevocable talaq. There's also different types of divorce orders. It's not just a divorce. There's khulu', there's nullification or fasakh, and then there's talaq. So that's also another very complicated system that we're dealing with. Mahr is a first priority debt to be paid before heirs receive anything, and non-Muslims generally can't inherit. So I will cover each one of these as we go along, but these are things to sort of bear in mind. The Australian system and the Islamic inheritance systems are very, very different. So why is estate planning especially urgent after separation, right? First and foremost, not because of separation, but Islamically, there is a mandate in which there's a hadith of the Prophet ﷺ that says it's not permissible for a Muslim who has something to bequeath to stay for 2 nights without having his will and testament written. So it's an Islamic obligation on everybody to ensure that they actually have a valid will. Now, why is it especially more important for separated couples? That's because separation alone does not revoke a will. Your separated spouse may still inherit everything if you die without updating your documents. So, if you die and you don't have a valid will, you are known as having died intestate. So intestate death is where the state intestacy laws apply, not the Islamic principles or not any principles other than the laws, because you actually died without a will. So this applies to separated and non-separated people. If you die without a will, the effect of that is you're known as dying intestate, which means that the intestacy laws applies. The intestacy laws actually say that your spouse gets everything, and there are certain circumstances where it may be your spouse and your children. That's very, very different from the Islamic system. So if you want your inheritance to be distributed according to your Islamic values and principles, you can't die without a will, because that means you're dying an intestate death, which means that the intestacy laws apply. That's the first thing. The second thing is, if you don't have a will and it's not documented properly and it's not risk managed properly, you risk family provisions claims being made by people who may be your spouse or children, or even a separated partner. So that's a big challenge. Like, for all intents and purposes, you think, okay, like, this person's out of my life. You're separated, it's not documented, there's no divorce order, the legal process hasn't been followed. This person may still challenge your estate, legally, not Islamically, but for all intents and purposes, we are operating in an Australian system, and they can bring a court application if they wish to do so. The third thing is your Islamic debt, so zakat, kafara, mahr, etc. If they're not documented properly and the will doesn't provide for them to actually be removed from your estate, they will not be met. So you risk Islamically meeting Allah subhanahu wa ta'ala without your Islamic obligations being accounted for. And the biggest thing for separated couples is the issue of mahr or dowries, which we'll cover inshallah in this presentation. Superannuation does not form a part of your estate unless you make a binding nomination in favor of the executor of your estate. So super and insurance do not come to your estate automatically. Super and insurance have their own binding nominations that you would have filled out when joining the industry or signing up to the product. So unless you go back and change that nomination, your super and insurances, by insurances I mean like life insurance and products that come into effect after your death, do not form a part of your legal estate. And finally, joint tenancy may automatically pass to your surviving, to the other surviving owner. And unfortunately, in family law practice, I had this horrendous case, subhanallah. We were in court for about 6 years, and this is under the old system before some of those family law reforms went through. We got to final hearing, and the matter actually settled through private mediation prior to final hearing. And if any of you have been through the process, you can understand what a I guess tumultuous time it would be to actually get to that stage. Before the final orders were actually signed, one of the partners in that particular court case actually passed away. And unfortunately for this particular person, there was no will, there was no sort of estate planning done. And the effect of what happened after that person's death literally meant that the last 6 years and all the documents we were working on and all the interim orders literally unraveled overnight. Everything from the arrangements for the children, from the property settlement arrangements, child support, everything unraveled by virtue of that person's death. So it's really, really important that you give thought to this to ensure that, inshallah, that you're making informed decisions about your life. So in terms of an overview of estate distribution from an Islamic estate perspective. So when you pass away, if I actually pass away as a Muslim and I've done my bit to ensure that my estate is distributed Islamically, what does that look like? What that looks like is the following. First, you have what we refer to as the gross estate. Gross estate is all your assets minus all your liabilities. So when we talk about assets, we're talking about house, we're talking about cars, jewelry, crypto, anything of value, your paintings, furniture, you might be a collector, anything of value, minus liabilities. Liabilities are mortgages, credit cards, personal debts, anything that you owe that needs to come out, right? So we minus liabilities from the assets, and you have what we call your gross estate, right? The other thing we minus upon your death is your legal and admin expenses, so applications to the court for probate if you have a will, or letters of administration if you die without a will. Funeral and burial expenses come out of your estate. and Islamic obligations should also come out of your gross estate. So for example, if you have unpaid kafara, if you have unpaid dowries, if you have unpaid zakat, that should all come out of your gross estate. So gross estate is everything before distribution, okay? Once we minus these liabilities and expenses, we're left with a net estate. The net estate is the kitty, or the little bowl of what we have for distribution to your heirs, okay? Now, Islamically, we divide that net estate into thirds. 1/3 is known as Wasiyyah, or up to a third, I should say, and that's called discretionary bequests. And 2/3 is known as Mirath or Fara'id, which is the fixed shares that I said Islamically is preset and you don't get a say in, okay? So what you need to remember is where you can make an informed decision and where it's really important that you do make some informed decision, it comes into the Wasiyyah section, the 1/3 of your estate that's actually discretionary, okay? Because the rest of it, if you do your will properly, following the Islamic guidelines, your estate liabilities, funeral expenses, Islamic obligations should all be paid out. You don't need to sort of get too entangled with that, as long as you have a compliant product, right? What you need to remember is this whole Wasiyyah section. What are we thinking about for Wasiyyah? And we'll touch base on that, inshallah. Now, you might ask, okay, you've told us that the 2/3 is the fara'id or the mirath is preset, and your natural question is going to be, who are these preset people that are supposed to inherit from me Islamically from the 2/3? Islamically, we divide the fara'id or the mirath into 3 tiers, so 3 categories of people that are to inherit from you. The first tier are primary heirs. They are your spouse, sons, daughters, and your parents. That is very, very different from the Australian system, which I said your primary heir is literally your spouse and or sometimes your children, right? Islamically, your parents inherit from you. Islamically, let me say that again, your parents inherit from you, and there can be circumstances where, for example, say your father may actually inherit more than your wife, okay? So it's really, really, really important that you understand, if you were to die right now, given your family dynamics, who's alive and who's dead, who actually inherits what, okay? So if we have the primary heirs available, we stop there. So if you have a spouse, you've got children, you've got parents, or you have a spouse and children, we stop there. That's the end of the calculation from an Islamic perspective. If we don't have any of the people that are primary heirs, so you don't have a spouse, children or parents, then we go to what we call secondary heirs, or T2. Okay, T2, they only inherit if T1 is absent. So this includes paternal grandfather, paternal and maternal grandmothers, certain siblings, sons' children, if the son isn't alive, and daughters of the son. So these are called secondary or T2 relatives. If you happen to be the last remaining relative, or a very sort of one of the last remaining relatives, you might find yourself in what we call distant kin category, or T3, in which T1 and T2 are entirely absent, and we end up with distant kin that we're trying to find to get them Islamically to inherit from you. So that's paternal uncles, paternal cousins, great-grandparents, and more distant relatives, and it really depends. It's like a whole Islamic way of calculating them. Now, I don't expect you to remember this, and the average person wouldn't remember this. We've taken the guesswork out of it for you by putting together a calculator on muslimwheels.com.au free of charge that allows you to actually simulate, if I died right now and I have a spouse, children, and parents, what is the percentage each of them gets? Get on Muslim Wheels right now as I'm speaking and do it, right? Simulate different scenarios. So for example, obviously none of us are going to know when we pass away, but if you died in 10 years time and you think, for example, in 10 years time your parents might not be alive, but you might still have a spouse and children, do a simulation based on that scenario. So Islamically, the fara'id work depending on who's alive at the time of your death, right? Which is very different from the legal system of you actually just appoint people. Okay, so please get onto our website and do that calculator. You don't need to understand Islamic inheritance shares to be able to make an informed decision. We've taken the guesswork out of that for you, and you can do that calculator. Now, who does not inherit under fara'id? Because I just gave you general categories. I said parents, spouse, etc. But Islamically, there are actual exclusions even from those categories that are very, very important for people to be aware of. Number one is grandchildren where the son is alive. Okay, so it's really important if any of you are grandparents and you're thinking of bequeathing to your grandchildren, grandchildren don't inherit automatically from you. So if you want to leave something to grandchildren, you need to think about that. That's number one. Number two, stepchildren, foster children, and adopted children. Step, foster, and adopted children do not inherit from you Islamically under the 2/3 of mirath. You need to provide for them elsewhere if you want them to inherit from you. Number three is non-Muslim family members, regardless of their relationship with you, whether it's your parents, your spouse, or your children. By virtue of someone being a non-Muslim, and by non-Muslim I mean like they're very clearly not Muslim. Like they've said, I'm not a Muslim. People know that, it's common knowledge. It's not, you know, a person who's not practicing enough by your standards Islamically. Okay. I'm not a Sharia scholar, and I'm not here to give Islamic advice. If you have any concerns about what constitutes Muslim versus not Muslim, go see a scholar or someone you trust and get that information. But the general blanket rule is non-Muslims don't inherit from you. So this becomes really, really important in two situations. Number one is if you're a convert and you have non-Muslim family exclusively, or if you have a mixture of Muslim and non-Muslim family members, because you need to think, how do I actually cater to them to risk manage my estate and prevent people from being left without an inheritance or bringing a claim against my estate. Okay. So it's again, you need to know what exclusions are to be able to make an informed decision. The other thing is, which is the last point, is if you have other family members that are important to you, that you might want to receive an inheritance from you, that don't apply under the fara'id, for example, because category 1 is alive. So for example, if you're a female and you have a sister and you want your sister, for example, to receive an inheritance from you, but at passing you have your parents, a spouse, and children alive, that sister, for example, won't inherit from you. So if you want your sister to inherit something, again, just as with anyone else that we mentioned in this category of exclusions, you need to make an informed decision about actually leaving her something. Or I just use sister example. It can be, you know, your aunt or someone else that's related to you that you think probably won't inherit because T1 relatives are actually alive at the time of your death. Okay, so it's really, really important that you read this in terms of the fara'id, who's eligible. So spouse, sons, daughters, especially, I think 90% plus of people fall into this category. You need to read this with the condition of if they fall into any of these categories, then they're excluded from the 2/3 fara'id, right? 2/3 fara'id being the Islamic mandatory inheritance. However, all these people, including non-Muslims, can inherit from the discretionary wasiyyah, or the 1/3, and I'll touch base on that in a second, inshallah. Now, this is a convergence of estate planning and family law. Divorce and separation. What does that mean? So you've already by now should have understood the Islamic landscape, like what things look like Islamically. Now we're talking about an added layer. What do things look like when you've got divorce or separation entering the picture? The first thing is an Australian divorce decree revokes gifts and executor appointments to a former spouse, but not the will entirely, unless the will has been specifically drafted for continuing to be valid even if a divorce order is issued. Okay, so for example, if you use the Muslim wills document, we've actually drafted it in a specific way that even if you get divorced, it still continues to be valid, because in our will product we don't name the fara'id, we don't name the people that Islamically would inherit from you. We have a whole system where the executor makes that determination based on the Islamic principles at your death. We also have very specific clauses in there that say, if, for example, I've nominated my spouse as my executor, and at the time of my death we are separated or divorced, that nomination should lapse. Okay, so it's really, really, really important. If you are using our product, always make sure that you update your nominations whenever you're getting married or getting separated or getting divorced. If you already have a current will, or you're thinking of doing a will and not using our platform and using it, going through a private lawyer, always remember, whenever you get married, divorced, or separated, revisit your will, because those appointments can become expired, or you might not want the appointment to continue. You might be separated from someone, you're not legally divorced, you just don't want them to be your executor anymore. Okay, so please, 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 if you've been divorced, if you had a will and you've been divorced and you haven't updated the will or made a new will, get into that tonight. Please don't leave it, because your previous will be very, very problematic. The other thing you need to know is property settlement orders under the Family Law Act override will provisions. So if you had a will and then you had final orders issued by the family court by way of a consent order or a final hearing, you need to revisit the will in light of the final orders to make sure there's no discrepancy between the documents, because a final court order, whether by consent or after a hearing, can actually override certain provisions of the will. Okay, and a binding financial agreement or consent order takes priority. So that's really, really important. The biggest nightmare, I guess, is separation. So people that are separated and not legally divorced. Why do I say this is the biggest nightmare? Usually when people get to the stage where they've actually applied for a divorce order or gotten the divorce order, they're sort of at the end of their divorce journey and attending to paperwork, separating assets, dealing with different assets becomes sort of like their new language and their new norm. They settle into that new norm. Unfortunately, that's not the case with people who are recently separated, people that are separated but living under the same roof, people that are sort of separated but get back together every 2-3 days and then separate again and get back together. Because the problem with that is it's a bit of a nightmare from an estate planning perspective, because for all intents and purposes, your separated spouse may still receive everything under intestacy laws if you die without a will. They can still act as your executor if you don't update the will, because you haven't had a divorce order nullifying that will. So if you didn't update the will, they can still be executor. They could still be a beneficiary under the will if you had previously given them something. They could be a guardian of your children under the will. They can make decisions about, your funeral. They can be your next of kin. Like, it's a whole nightmare if you're separated, but no one really knows about it. Even from a family law perspective, a lot of the issues we have in practice where you go to a solicitor and say, can I get a divorce? And they're like, okay, cool. Have you been separated for the last 12 months? And you're like, yeah, I separated like 6 years ago. And they're like, okay, let's discuss it. Can you give me details? Where do you live? Oh, we live under the same roof. Okay, like, do you share bedrooms? Sometimes we do, sometimes we don't. Does anyone know you're separated? Not really. Like, we don't like people to know we're separated, so we like act like a couple. We attend functions like a couple. All right. Do you have separate finances? Not really. Like, we have a joint account and we just sort of do our own thing, but it's still a joint account. Even from a family law perspective, you're going to have a very hard time proving to the court that separation exists, because the court likes to see what they call a clean break. A clean break principle means that there needs to be some sort of separation. Like, you can't just be separated but not separated, together but not together. And I think, unfortunately, a lot of people fall into that very grey space just by virtue of it's just too hard. Like, and I'm not coming at this from a place of judgment at all. I can appreciate how difficult it is when you've got children. There might be domestic violence, there might be trauma, there might be a whole plethora of things going on for you, that getting things legally ticked might not be your priority. But unfortunately, if you do die in that hybrid space, there can be serious implications for you. Okay. The other thing is, if you're going back and forth, yo-yoing from an Islamic perspective in terms of talaq and taking a person back, talaq, taking a person back in the iddah period, that can actually be quite problematic, because Islamically there's a difference between a wife being able to retain inheritance rights when she's still within the iddah period of a marriage where she can go back, or a revocable talaq, versus a final talaq in which it's the end, and unless she marries someone else, that husband can't actually go back to her. Okay, so it's really, really important that you see a sheikh that you trust and you document Islamically where are you at with this talaq situation. And as I mentioned to you previously, superannuation and separation, superannuation and those benefits don't form a part of your estate. So if you still have binding nominations in favor of your ex, even if you have a divorce order, you have a very big problem. So please, especially if you've already separated and you've already had a divorce decree, if you haven't remembered to actually update your super or your insurances with those binding death nominations, you can potentially still get your ex receiving things, which can be problematic. So please look into that. All right, practical issues. The other thing when we're talking about estate planning and death is that you might not want a meddling ex-spouse being involved in your business after your death, even though you're not around. But they may still have the legal power to do so because you didn't document your wishes properly. Okay, so unfortunately, under the next of kin regulations, A separated spouse that's not legally divorced from you may have legal rights over the body, how it's treated, how it's dealt with. So it's very important in your will that you document who you want to view and not view your body. Very important. Name the person responsible and tell your executor, tell the funeral home, tell people of your wishes. That's number one. Number two, Islamically, your body needs to be washed, right? A ghusl needs to be performed on your body. You need to nominate who that person is going to be. If you don't have a nomination and your ex thinks that they can just waltz in and do that, and you haven't told anyone you're separated, you might have a problem there. Okay, so make sure that you document exactly who the person for ghusl is going to be. The other thing is, if you and your spouse are of different faiths, or someone's practicing, someone isn't, or you're just estranged from your spouse, it's really, really important that you document these wishes. And not leave it up to chance, because you can potentially end up with a really sort of ugly scenario. There was a very, very unfortunate case in which there was a very ugly legal battle in the estate of a convert sister, in which there was a discrepancy or a disagreement between the former husband, who was a Muslim, and the sister's family, who are non-Muslims, about the encryption to put on her tombstone. They were in the coroner's court and they were fighting, and that sister's body was held in the morgue for 6 months. 6 months while the ex-husband and the non-Muslim family were fighting over names for a tombstone. Do not leave it up to chance, especially if you have estranged family members, non-practicing members, or people that are not very involved in your life. Document every single one of these things. What's the tombstone? Which parlor, where are you going to get washed, which cemetery, who is your ghusl person, who's going to lead your janazah, who's allowed to attend, who's not allowed to attend. Document these to the T, please. Who controls the funeral? Without clear documentation, a separated spouse may legally control your funeral, because in the absence of a will nominating a funeral director, a separated spouse can nominate themselves as a funeral director, as your next of kin, and take authority. Okay, so make sure that you nominate your funeral director.
Tasnim, I might just jump in there since we're on the subject of washing. Does the mosque then have any power or authority to override any wishes that may or may not be present in a will?
No. So if you have a legally valid will that's been executed properly, legally that's binding and enforceable. Unfortunately, though, having said that, if you haven't briefed people that are close to you, so for example your executor or your family, about the will, people might make decisions in the spur of the moment without sort of reference to your documents, because they're just not aware of them. So I'll give you an example. Islamically, as you would know, we have a really huge injunction to bury as soon as possible. Like Islamically, the person dies, they should just be buried as soon as possible. If you haven't already had a conversation with your family about who the executor is, where your will is, and what your end of life wishes are, the chances are your body is going to be at the funeral parlor being washed before anyone's even seen your will, right? So then the problem then becomes, you actually didn't do the best by your family, because you sort of left them in a situation where they're trying to just, move things along, get you buried, do the Islamic right thing by you. But because they weren't actually briefed about who your executor is, where your will is, and your end of life wishes, that they might look at the will or contact your solicitor or what have you a week or a month after your death. So unfortunately, sometimes it's not a matter of can they make that decision legally. Sometimes practically that decision ends up being made because of an absence or a vacuum of information being shared. So it's all about having the right information, making informed decision, and having that support network around you, so we don't end up with situations, as you mentioned, Soumaya, where, for example, wishes or things are being made without your consent. The other thing is, if you have, for example, you clearly don't want an ex-spouse to be at your janazah, viewing your body, or in the maghsal, for example, let your executor know. And for example, if you have a preferred funeral parlor, or even, I know some people, for example, have prepaid funeral plans, like Gallipoli Mosque actually has a prepaid funeral plan. You should have all these documentation in that and share that with these service providers and let them know. I can guarantee you 9 out of 10 cases when these service providers are told this person can't come in or this person shouldn't be a part of it, they're going to err on the side of caution and listen to that. Whereas if no one's telling them this was actually the wish or this person shouldn't be in, on the day they just might freeze and be like, well, they just said that they were the spouse and we just let them in, right? So don't leave it up to chance. Take agency, take control, and document all those wishes. That also leads on to the next point, janaza attendance. So if there's specific people that, this doesn't even have to be an ex-partner. If you have like people in your life that you really don't want to be a part of that end of life space, which is quite sacred, and I think from an emotional perspective, quite triggering. For example, you might not want like a particular person to come, which may actually trigger your family members, like whether it be your parents or your children or what have you. You should know in your end of life wishes, I want this person to be excluded, right? And at the end of the day, like have the agency to be able to make those informed decisions about your life and your end of life, to be able to, I guess, protect your loved ones and those that you leave behind, inshallah. All right, this is child guardian nomination. So this is a convergence of custody issues and estate planning. So if you are a separated person, you may have had either a parenting agreement or parenting orders in relation to your children during your lifetime. Now, in your will, so those, sorry, I should say, the parenting plan or the parenting orders operate during your lifetime. After your death, that ends the orders. Like the orders don't continue after your death, right? So in that space, the following comes into play. Number one, if you've made a testamentary guardian nomination, so a testamentary guardian means a guardian for your children that you nominate in the will as being the person to take over in terms of the caregiving of the children after your death, the court will give that significant consideration. And it's very important that you try to nominate a guardian, a primary guardian, and a secondary guardian, okay? If you and your partner or the father of that particular child are on talking terms, I highly encourage to have that difficult conversation and have the same person nominated as the children's guardian in the event that you're both deceased, or sometimes even in the event of if either of you deceased or the person that had parental responsibility, for example, because if you guys have discrepancy between who you nominate, it may potentially end up in the family court, okay? So your testamentary guardian nominations are not legally binding and enforceable if a court hears a matter and makes a decision, okay? So in the first instance, make them, but just always know that if that's ever challenged in the family court can still make a determination based on what they call best interest of the children, and nominate who they think to be the particular or the best guardian in that instance. So to lessen the chance of that happening, number one, for yourself, make nominations. Number two, where possible, contact the biological parent of your child and try to have the same person. That way, the chances of that being challenged are dramatically lessened. If your ex-spouse, if you have a living ex-spouse with parental responsibility, they are likely to take custody of the children regardless of your nomination, okay? Now, that's really, really important, especially if you have a parenting plan or you don't have any documented wishes, because a parenting plan can be taken into consideration, but it's not legally binding and enforceable. A parenting plan is not like a court order. Or you and your former spouse may have just organically agreed on when he picks up the children or when you pick up the children without that being documented. And then if you pass away without any sort of formal documentation, the ex-spouse legally just continues to actually have that parental responsibility, okay? So it's really, really important to review that, especially if that person, in your opinion, is actually like not suitable, or if that person becomes incapacitated or deemed unfit, where's that nomination going to go, okay? This is where you can actually document some of your thoughts, document some of these wishes, let your executor know about them, let your family members know about them. So again, like that family law case that I started with, unfortunately, like her immediate family and his immediate family weren't actually aware of the intricacies and the dynamics of the court system. So when one of them passed away, there was sort of a bit of a, well, what do we do? Like there was actually no documentation from either of them in relation to what happens to the children. The other thing to consider, it's really important. You may have like custody arrangements, or like they're not called custody in Australia. It's called time with, or spending time with, or other parental responsibility decisions. And you may have financial guardianship. Okay, these are distinct categories. So you might have your children, for example, spending time with someone, but the financial responsibility may fall on someone else. Okay, so it's really, really important if you have some of those dynamic arrangements, or you have like a private child support agreement or a court order, that you give consideration to how are those arrangements going to continue if you actually passed away. Okay. The other thing you should give consideration to, especially if you're on a good relationship with your former spouse, or the father or the mother of your children, is give consideration to potentially like a structure that outlives you both, that caters to people that are financially dependent on you. And we're talking here about, like minor children, children with disabilities, especially children with mental health issues, or people who are financially dependent on you. So something like, for example, a trust structure. Trusts are companies that are set up that are not in your personal name. Like you might be, a beneficiary, you might be a trustee, but you are not the trust. The trust is a different legal structure to you. Okay. So trusts have what we call longevity, and they can continue. Okay. They're not extinguished by virtue of your death. So if you and your partner are at that level, or sorry, your former partner or the biological parent of your children are at that level where you can have some of these conversations, you may wish to give consideration to setting up a trust for your children or financially dependent people. So if either of you die, the financial contributions and benefits can continue to flow to those people who are dependent on you financially. All right, Mahr, dowries and financial settlements. I can guarantee 9 out of people don't know this. 9 out of 10 people, I should say, don't know this. Mahr is Islamically payable out of a deceased estate before distribution to heirs. Mahr, dowries that are unpaid, that continue to be unpaid, and the person who's supposed to pay them, which is usually the male, passes away. Mahr needs to come out of that person's deceased estate prior to any distributions of inheritance. In my private practice, I can guarantee that almost 9 out of 10, to be honest, I've never heard of a case of Mahr actually being paid out of a deceased estate, right? So Islamically, if we're talking about, being true to values and bringing an Islamic estate distribution, let's give serious consideration to these obligations that we enter into. So Mahr, as you would have known, I'm assuming most of you would have known this because you've obviously been married, or may currently be married. There's 2 types of Mahr. What we call mu'ajjal, which is a deferred Mahr, or muqaddam, or prompt Mahr. Okay, so the Mahr that's payable right now, like the muqaddam Mahr, the payable right now, usually is paid when the people get married. Or for example, like people might say, the furniture, or I don't know, the car or whatever is my mut'addam, or my immediate Mahr, right? Then you might have an amount which people say is my mut'akhir. So this is my deferred payment, right? Usually that deferred payment is actually a very, very high amount, and most people don't end up making those repayments during their life. Okay, so if you're a male and you haven't actually paid your mut'akhir or even your mut'addam to your spouse, Islamically there's 2 sets of obligations that you need to think about. Number 1 is, what does that mean for you during your lifetime, and where does that sit with, for example, property settlement, if you've had a property settlement? And number 2, upon your death, how do you ensure that that debt is actually paid out of your estate before the inheritance is distributed? Because if that debt doesn't come out of your estate, Islamically, you've got an obligation towards Allah subhanahu wa ta'ala that you haven't fulfilled. Okay? So just remember that. Number 1, Mahr is a priority estate debt. So you need to make sure, especially if you've already had a will drafted and you haven't paid your Mahr, that you put in your will that the Mahr has to actually be paid. That's number 1. Number 2 is Mahr isn't immediately binding unless you, from a family law perspective, unless you had, for example, a binding financial agreement that was drafted in a way to ensure that the Mahr becomes binding and enforceable. Okay, so think about financial settlement and Mahr, where that sits and how that works, and document everything in your secure vault. So I'll explain that in a second, but with Muslim wills, we give you access to like an online depository of documents. But in your own documents, if you've already paid your mutaqaddam or the original amount, know exactly when it was paid, how it was paid, to who it was paid. If you've got a deferred amount and you've been making repayments, document those repayments. The other thing you need to remember is if your mutaqaddam or the immediate payment was actually, for example, say household furniture, and say a car, and that was actually payable as the mahr, then technically that should actually be excluded from the property settlement, because that is the ownership of the female who was supposed to be given the mahr. Okay, again, may not be binding and enforceable from a family law perspective under property settlement, but if we're talking about bringing Islamic values and principles to the system, we need to give consideration to these things. I know this topic we can spend 10 hours on mahr and financial settlement alone, because it's a really big area. But just remember these key points and just go back to your lawyers and whoever advised you as you navigate this space. The other thing is trusts. So trusts can be a problem, but they can also be a good thing. Okay, why do I say that? Some of you might have encountered the issue of trusts in a family law space where you were dealing with property settlements, for example, where a person's assets were as a part of a trust and they were attempting, for example, to exclude those assets from property settlement because they were part of the trust. So that might have been your interaction with a family trust, or some of you may be actual beneficiaries of a family trust, right? The issue with trusts is, as I said, it can be a double-edged sword in that it can be useful to be able to set up structures outside of individuals, because trusts outlive you. They could be a really great tax maximization if you have businesses and companies and what have you. And they can also be really good to provide for someone during your lifetime. Okay, so Islamically, there's actually a difference between hiba or gifts during your lifetime and bequests. Okay, so bequests are things that happen after your death. Who receives inheritances, whether compulsory or optional, they're called bequests. That's after you die. Before you die, you can actually gift things or set up structures during your lifetime, and there's no Islamic restriction on that. Okay, so you may give consideration to, for example, a testamentary trust, a discretionary family trust, a special trust, a waqf, etc., to set up during your lifetime, so that certain people can benefit from your wealth. I just gave the example not long ago of children and finances and minors. And it can actually be a good succession planning tool to ensure that those who you want to receive certain entitlements from you receive those entitlements through the trust structure without going into your estate. Now, I'm not going to spend too long on this because trust law is quite complicated, and the different types of trust can mean significantly different things. I just want you to sort of give thought to the fact that there are structures outside of your personal estate known as trusts that you can utilize to pass assets down generations if you wish to do so, or financially provide for certain members if you wish to do so, or set up for philanthropy and giving, such as a waqf, for example. Okay, so that's trust in a nutshell. Now, what does your will need to cover? So this is sort of, we've covered the difference between legal and Islamic estates. We've covered some of the issues with family law in terms of children, property settlement, and dowries. Now I'm bringing it all together in terms of, okay, now we've sort of understood some of the red flags. What do I need to make sure that my will actually covers? So if you already have a will, please make sure that you review your will to make sure it caters to this. If you don't have a will and you're thinking of using our platform, don't worry, this is all provided for. If you're going to go to a private lawyer or see someone else, please make sure that this is provided for. So personal and legal. So you need your full personal details. You need to revoke previous wills. And as I said, if you're separated, please get onto this ASAP. Make sure that your executor nominations are valid and current, especially if you have former spouses nominated as your executors. Make sure your guardian nominations are current, and as I said, where possible, try to speak to the person's, the children's other parent to have the same nominations. If you have specific instructions, for example, you want them to attend particular schools, or you want them to do hifz or what have you, document that. Have all your assets distributed through the document, including digital assets. And if you have any business interests and shareholdings or companies or what have you, ensure that you have the right succession planning documents for those structures, and that's not necessarily covered in your personal will. So if any of you, for example, have a business, have a company, have a trust, you would know that when setting up these structures, you can have a whole range of roles and responsibilities in those structures. You may be anything from a shareholder to a director to a beneficiary to a trustee. These are legally very different categories, okay? Your personal will doesn't actually provide for what happens when you die to these particular roles. So if you are the holder of a business or a partnership or a trust, or a beneficiary of one of those structures, you really need to get legal advice to ensure that both your personal assets as well as any assets and roles or responsibilities in those other structures are provided for. So in the event of your death, we're not left with a vacuum. In terms of Islamic obligations, this is particularly relevant if you already have a legal will that was drafted, especially by a lawyer that didn't specialize in Islamic wills. Make sure that your Islamic obligations that are outstanding at the time of your death come out of your estate prior to distribution to your heirs. So that includes unpaid zakat, kafara. Kafara, by the way, I should have said this earlier, sorry, is, for example, expiation for a certain Islamic wrongdoing. Okay, so for example, if you had particular oaths that were not attended to, particular fasting, etc., there's certain Islamic obligations that even after your death still need to be expiated if you didn't perform them. So if you're not sure what those are, get some Islamic advice. They're your debts to Allah. They need to be paid. And that includes dowries. Number 2 is wasiyyah. Think about your 1/3 allocation, and I'll touch base on wasiyyah in a second. With your fara'id or your 2/3 that are non-discretionary, make informed decisions. Know who's going to inherit from you so it's not a shock to the system. If you want to claw superannuation and life insurances into your estate, you need binding nominations in favor of the executor of your estate. This is an actual hard copy form that needs a wet signature that you need to give to your super provider, if you're with an industry super fund, saying, I actually want the funds or whatever benefits I receive from my super to go into my estate to be distributed according to my will. And if you follow our product, we have prompts for you in terms of how to do that. If you're not using our product, contact your super provider and ask them to make or give you the form to make a non-lapsing binding nomination in favor of the executor of your estate if you want the benefits to come to your estate. And that also applies for life insurances. And also, if you have overseas burials or overseas family members, you really need to give thought to the Islamic issues with that. Because Islamically, your body can't be embalmed. Like, you shouldn't tamper with a dead person's body. So after your death, we really shouldn't be touching your body. So don't, when people want to sort of be buried overseas, that's going to involve embalming of your body, which is Islamic actually prohibited. So give thought to some of those considerations if you already have that in the will. And finally, if you're a separated couple, or if you have a complex estate, give thought to obviously updating your executor, your guardian, and beneficiaries. If you have estranged family members, document that in your will. And also Islamically, even if someone is estranged, they can still inherit from you. So just bear that in mind. If you have non-Muslim family members, make sure that you provide for them. Or for example, if you have stepchildren or what have you. If you have disabled beneficiaries, make sure you give them special consideration. If you have second marriages or multiple children from multiple relationships, you need to sort that out because there may be differences in terms of how they inherit from you, whether you're the female or the male. And if you have overseas assets, there might be different laws that are applicable in that particular country in terms of how those assets are to be divided. And you need to get advice from that particular country on whether or not an Australian will is actually valid in that particular country. So that's something really, really important to note. Now, whether you use a secure vault on our website or whether you have your own documents, this is sort of a cheat sheet for separated families. Please make sure that you attend to this after today's seminar. So this is like my take-home message. What do I need to think about? Your marriage certificate, nikah contract, divorce orders, talaq, khula documentation, dates of separation, when you were separating, how you were separating, who knows about the separation, document all that. If you have mahr, how it was paid, who it was paid, when it was paid, receipts, pretty much everything, witnesses. If there's restrictions on, viewing your body, janaza attendance, make that known. If you have burial location preferences, if you've already purchased a funeral plot, if you have instructions for who you want your service, which masjid, document those. You need a financial and asset register because your assets aren't actually listed in your will. So keep a current list of these are my assets, these are my liabilities. So that way, if you pass away, your executor actually knows, where is your estate, where are things at. And please, please, please remember, if you own a property jointly as joint tenants with another person and you pass away, the other person gets the entirety of your estate under survivorship laws. Okay, so if I and my husband own a property as joint tenants and I pass away, my husband gets 100% of that property as a surviving a joint tenant. If you don't want that to happen, you need to sever the joint tenancy, and there's different things that you can consider, such as tenancy in common. Tenancy in common, you can actually allocate shares. So for example, I can allocate 50% to me, 50% to him. So if I pass away, my 50% actually goes through my estate and to my heirs. Okay. Or you can do 30-70, whatever the arrangement is. But please make sure you revisit your ownership documents. Superannuation, bring that in if you want it to be a part of your estate. Same thing with life insurances, business interests, make sure that you account for that, and digital assets. And finally, from an Islamic perspective, make sure that the Islamic distribution is accounted for, especially if you've already got a will that hasn't been drafted in compliance with Islamic law. Make sure that you've got your guardians, your waqf intentions, charitable, sadaqah preferences, etc. done. Now, this is the last thing I'm going to cover before we go to Q&A. So the 1/3 of your estate that's discretionary or called wasiyyah Islamically, this is where you can actually take agency. So everything that I sort of discussed with you, it's almost like that's, by the way, you need to know this, but there's not much you can do about it. From an estate planning perspective, the wasiyyah, or the 1/3 of your net estate, which is discretionary, is absolutely where you can do things about and where you should do things about. All right. So from an estate planning perspective, this is where you need to actually get moving. So wasiyyah, the 1/3 of your estate that is discretionary, who do you need to think about? Who should go in your wasiyyah? Number one, you can support non-heirs. By non-heirs, I mean people that are not receiving the Islamic inheritance from you under the 2/3. So non-Muslim relatives, stepchildren, estranged family, those who can't inherit under the mirath, etc. That's number one. Number two, consider charitable giving or sadaqah jariyah. Okay, it's really, really important. Allah gives you the ability to take agency and have a legacy of giving that continues after your death through your will. So don't say, oh, I see this in wills all the time. If you remember me, please give charity. Don't leave it up to people to remember you and to please give charity. Take agency and give the charity as a bequest. That way, that charity is actually deducted from your estate before your heirs get things. So Islamically, you've almost guaranteed your sadaqah jariyah. Okay, so give thought to that. Honor informal Islamic debts. So if you have any Islamic debts that are informal, make sure that they're accounted for in wasiyyah. If you want to give something extra to an Islamic beneficiary, so for example, I want to give an extra amount to my mum or my daughter. I know Islamically they're going to inherit from me, but I want to give them an adjustment. Islamically, I can still do that through the wasiyyah as long as it's with the consent of the other Islamic beneficiaries. Okay. If I don't want it to be with the consent of everybody else and I want it to just happen, do it during your lifetime, because Islamically you can do whatever you want with your money during your lifetime. And finally, use wasiyyah as a way to risk manage your estate from family provision claims. Family provision claims are claims brought by financial dependent people to the Supreme Court to say, hey, this person didn't give me something in their will, or what they gave me wasn't enough. Hey, judge, please give me more. The way you can sort of risk manage those claims is by actually providing for people who you think might bring a family provision claim, to ensure that they actually don't bring a claim. And the keynote in terms of family provision claims is who's a financially dependent person on you. So that can be children, that can be a spouse, that can even be like, I had a case in which someone's niece was brought from overseas to take care of them, and the niece cared for that person for like 10 years. That niece, who was already provided for in the will, brought a family provision claim saying what was given to me wasn't enough, I want more. Okay, So give thought to people who financially may be dependent on you, and that's really, really important. Document your end of life wishes. So tell your executor, tell them where your will is, what your wishes are, update your end of life wishes, tell the people who are going to be washing your body, hey, by the way, I've nominated you, and have a conversation with your family and your children about your end of life wishes. So that way it's actually not a shock to the system if you pass away. And if you do have young children, it's really important that you give sort of thought to who's going to sort of fill that gap or take over affairs after your death, especially if you're not on good terms with your own immediate family. Now, muslimwills.com.au, as Soumaya mentioned at the outset, is a bespoke platform that we've developed, drafted by lawyers, reviewed by a barrister, and the Islamic side of things was actually drafted by a professor of Islamic law. And what you'll find on there is a plethora of resources. So everything from what's an executor, what is wasiyyah, what is mirath, we've got it outlined. Go on there, it's free of charge. Number 2, we have an inheritance calculator. The inheritance calculator allows you to find out Islamically, if I have these relatives at the time of my death, what are their corresponding Islamic entitlements in terms of mirath, okay? Do the calculator like without negotiation. Everyone should do the calculator. It's absolutely free. Why do I need you to do the calculator? Because when you understand Islamically who's going to inherit from you, you can make an informed decision about who is going to be receiving your wasiyyah or mirath. Sorry, receiving your wasiyyah or your discretionary bequest. So for example, you might be like, oh, I didn't know my wife just inherits this amount, or I didn't know that my son inherits just this amount. I actually need to provide for them to be able to keep a roof on their head, for example. So you might need to give them something in wasiyyah, you might set up a trust, you might give thought to things you can do during your lifetime. The will itself is $99 plus GST, and I'll give you a discount code for today's session. And finally, we have what we call a secure vault, which is an encrypted system that only you can access, where you can update or upload everything else that I've just discussed that's not just your will. So assets, liabilities, letters to your executor, letters to your loved one, whatever you need is really, really important. And that's pretty much it. I've just got the details of Muslim wills on there. I'm so sorry, guys. I've just frozen. I need to. Soumaya's just dropped off, so I'm just admitting her again. All right. So Soumaya's just back on. So these are our details. And for tonight and for the rest of the week, inshallah, we've got the New Beginnings code to receive 10% off our wheel product, which is NB10. All right, I'm just trying to, sorry everyone, thank you so much for your patience. I'm just trying to admit Soumaya back in so she can do our Q&A session. I think she just had some internet problems. All right, Soumaya, if you're back online.
I'm back.
Okay, that sounded intense. I think you might have 2 devices logged in. So maybe just put one of the devices on mute.
Can you hear me now?
With a bit of an echo. Sorry, Soumaya, we can't hear you.
All right, third time lucky.
Perfect.
Thank you all for your patience. Technologia. All right, the good news is I was actually typing the questions out on a separate document, old school all the way. I haven't been able to check to see if we've had any other questions, but what we might do is I'll jump in and some of those really, thank you so much, Tasnim, for those the information, a lot of it is pertinent and relates to real life scenarios that you've articulated so well, and they're so relevant. So I think a couple of the questions maybe you've answered in that presentation. One of the offshoots of who can and can't inherit from the will, an Islamic will, related to the non-Muslim spouse. Now, one of the questions in the chat sort of continued on and said, well, can this person then contest my will? If I create an Islamic will, where does that stand in the legal system? Can it be challenged and contested is the right word, I guess.
Really, really good question. And I think this is actually even interesting from an Islamic law perspective, because especially for males, Islamically, you are allowed to marry people of the book. So Islamically, it's not even a difference of opinion. It's something that's allowed. And a lot of people, especially males, may have a valid Islamic marriage because they have married a person of the Jewish or Christian faith. Now, Islamically, even if your marriage is valid, if that person is non-Muslim at the time of your death, they can't inherit from you. So to prevent this very issue, which you said, them being bringing a family provision claim, if your spouse is non-Muslim, it's an absolute non-negotiable, I would say, for you to make sure that you list them in the Wasiyyah. And Islamically, the portion that they actually might receive from the Wasiyyah might even be, depending on your family dynamics, might even be more than what they would have inherited Islamically, right? So they're not necessarily losing out by not inheriting Islamically if you ensure that they're catered for in the Wasiyyah section. That's number one. Number two, give consideration to structures or legal things that you can set up during your lifetime that don't have an Islamic restriction. Okay, so for example, I can allocate my non-Muslim spouse, for example, a life tenancy in a property I own that allows them to continue to live in the property during their lifetime. And once they die, that particular asset is distributed to my Islamic heirs or whoever's supposed to inherit from me. Okay, so it's not like they don't inherit, it's the end of the story and it's doom and gloom. There are different ways to cater to the people who Islamically don't inherit from you, such as your non-Muslim spouse, during your lifetime and at your death through the Wasiyyah. And I'm so glad this is being brought up, because you can actually do something about it right now, and don't leave it up to a scenario in which they're challenging your estate upon your death.
Yeah, that's a really good way to answer it. So I guess then it comes under the that 1/3, the non-fara'id section. That would be the
yes. During for your estate distribution, but there's still things you can do during your lifetime that don't have Islamic restrictions, such as gifts, trusts, life tenancies, and a whole host of things to cater to this person to ensure that they're not challenging your estate upon your death.
Fantastic. So we did have, just in relation to the section you covered on what goes into a will. Okay, so I guess you covered the personal information and all of that. And one of our participants in the chat was asking, how granular can we get? Where do things like bank accounts, passwords, access to social media accounts, are they things that you can incorporate in the will? And if yes, does it form part of that, an information dump of personal information, or is it categorized separately?
Yep, really good question. It doesn't go in the will. So think of the will as your macro directions for your estate that give direction to the people at the time of your death in terms of where you want your assets to go. It doesn't actually cover, most wills don't cover what your assets are. And the reason why the will doesn't cover what your asset is, or what your assets are, I should say, is the moment you have an asset or you lose an asset, you're going to have to update the will, right? So imagine you buy a car, let me update the will. I sell the car, let me update the will. Oh, I bought a necklace, let me update the will. Oh, the reason why we don't put assets and liabilities into the will is every time there's a change by way of a loss or a gain, your will is going to be invalid, right? So what we do is we have the will covering the macro and minimizing the need for change to ensure that it's always valid, and you don't just happen to have a life event and then your will becomes invalid. Okay, so assets, liabilities, family members, your separation details, your passwords, your crypto, that information dump, if you're using app platform, will go on Secure Vault, and no one other than you and your executor with the encrypted passcode at your death can access the Secure Vault on our platform. If you're not using our platform, think like, get creative. Like, do you have a hard, you know how people still have safes, for example? Like, are you gonna write this information, print it out and keep it in your safe? Are you gonna give it to your mum to put under her pillow? Like, whatever works for you, but make sure that you have a very accessible list of assets, liabilities, passwords, family members, and what's going on in your life, so your executor can actually manage your estate upon your death.
And just on the subject of the vault, one of the questions that came through was a query. So if people go ahead and create a Muslim will through Muslim wills, is this something that's stored in the New South Wales will safe?
No. So legally, we just didn't have time to cover this. What makes a valid will in terms of execution, right? So we've drafted the will, we put in all the things that we want to put in. How do we actually make sure legally it's valid? In New South Wales and Australia generally, a will becomes valid the moment it is signed, and I'm talking about wet signature, not on your tablet, not electronically, not secure whatever DocuSign. It has to be signed in person, in the presence of two witnesses that are not named in the will and that are not likely to inherit from you, right? So Islamically, that's pretty much anyone you're related to, because at any given point in time, one of them may inherit from you. So it can't be your executor, it can't be someone who's likely to inherit from you. They physically need to see you sign. Legally, the moment you've signed, your witnesses see you sign, and they also apply their signature to the document, that becomes a legally valid will, full stop, okay? There's actually no requirement to register a will in Australia. So these safekeeping, it's just literally safekeeping. There's no system in Australia to actually register a will, okay? So whether you're using safekeeping through Guardian, New South Wales Children's and Guardian, for example, or any other thing, that's literally storing the physical document. You need to know the moment your signature is applied, along with that of the two witnesses, it's a legally valid will.
Thank you for that. And on the subject of legally valid will, then is the will valid in New Zealand, or does it need to be created in that country or jurisdiction?
Yeah, look, that's a good question, and I touched on that in terms of overseas assets. So the answer is I don't know, because it depends on what jurisdiction we're talking about. My gut feeling is if it's a Commonwealth jurisdiction, so for example, if we're talking about like Britain, Singapore, New Zealand, the courts may sort of take a liking to it and are more likely to potentially accept it if it meets the other legal requirements in terms of how wills are to be executed in that country. I can tell you, for example, the Muslim countries won't accept this document because it's a completely different system to how they operate. So if you have assets in an overseas country, or you have significant family members in an overseas country, I'd highly encourage you call the embassy or the consulate and say, if I have an Australian will and I want that to be valid in Lebanon, Bangladesh, Pakistan, whatever, how do I go about doing that? And they should, I hope, be able to tell you whether you need a fresh new will in that particular country, or whether there's a document for registering your Australian will in that particular country.
And that's a good segue into a couple of questions that we got around, well, what if your relatives are overseas and you happen to pass away here?
Yep.
How do you reach these people? And the other one is, can the primary trustee be someone who lives overseas and doesn't hold a visa for entry into Australia?
Yeah. So overseas applies in a whole bunch of issues. Number one is executor. Can my executor be overseas? Number two, can my nominated children's guardian be overseas? Number three, can my Wasiyyah beneficiaries be overseas? Number four, what happens if my Mirath beneficiaries are overseas, right? The answer to all those is, the basic legal ruling is, them being overseas doesn't impact those roles or those benefits they're to receive, with some conditions. So for example, I would caution against appointing an overseas executor by virtue of the fact of the logistical nightmare it's going to be for them to administer your estate if they're in a different country, right? How are they going to sign documents? How are they going to make applications to the court? How are they going to like retain a solicitor to, you know, go through whatever administration processes are required? Okay, so that's for the executor. For the children's guardian, if your children's guardians are overseas, who's expected to take care of the children in between the time where you know, they come to Australia, or are your children expected to go overseas? Like, how does that work in terms of logistics? In terms of actually receiving an inheritance, whether through wasiyyah or mirath, you being overseas doesn't prevent you from receiving that benefit, but you need to give consideration to certain tax issues. So if a significant portion of your assets is overseas, or a significant majority of your beneficiaries are overseas, I would strongly suggest you get some tax advice about what that might mean for you, because it can have consequences for your estate from a tax perspective.
Now, Tasnim, can you still hear me?
Yes, I can. I can hear you, but your picture's frozen.
That's fine. I can stay frozen in everybody's view at the moment. Can the beneficiaries who are considered primary heirs also inherit from that 1/3?
Yes, as long as the other Islamic heirs approve of that additional amount going to them. So, for example, I have a spouse, my parents, and my children. And as I said, I want to make an extra allocation to my daughter, for example, from my Wasiyyah section. Islamically, my spouse, my other children, and my parents need to agree to that additional bequest going to her. So Islamically, yes, as long as it's with the agreement of all the Islamic beneficiaries. If you don't want it to be with their agreement, like if you just want to make that decision, set up something during your lifetime, because there's no Islamic restrictions in terms of what you do with your wealth during your lifetime. But after your death, there is an Islamic restriction.
And I guess then that would apply to children who are not biological, stepchildren. So if you know, if somebody's raised their spouse's children and they've spent a great deal of time, then they've gone ahead and got divorced. If that person wants to leave something behind, without them being entitled to any legal inheritance, is that the same thing then as that 1/3, as long as everybody who is part of that fara'id component agrees?
No. So if it's the spouse's children, so it's not their children, it's a spouse's children.
Stepchildren,
so stepchildren, you don't need the agreement of all the Islamic beneficiaries.
Right.
The only time you need the agreement of the Islamic beneficiaries if another Islamic beneficiary is getting an additional adjustment, because what that means for them is, like, technically all the other beneficiaries are going to get a bit less, right? However, if the person you want to leave in your wasiyyah is not an Islamic beneficiary, you don't need the consent from anyone. As long as you have a valid bequest in the will, Islamically and legally, that should go through.
So my chat's frozen, but I do have a question here. If we have a joint bank account and we die without a will our child be able to access the funds?
So I'm assuming they mean like concurrent death, like the owner and the other joint owner die concurrently. Is that what you think they mean?
Well, yeah. Well, I guess one or the other. There's a joint bank account, right? So there's, I guess.
So there's a difference legally, right? If you have a joint bank account, or if you have a property that you own jointly, as I said, the laws of survivorship apply, which means that the other owner gets the complete amount. So if me and my husband have a joint bank account, and bank accounts, I just want to clarify, when I mean by joint, it's like both of your names are on the bank account. It's an actual joint account. It's not where, you know, for example, where you can give someone the authority to access the account or like receive communication, but the account is still in your name. I'm not talking about that authorization. I'm talking about where it's an actual joint account where both people's names are on the joint account. The legal principle is, if you pass away, the other owner gets the entire amount, whether that's of the bank account or whether that's of the house. Okay? So no, your child in that instance won't get anything, because the other surviving owner will get everything. If you and the other owner die concurrently, then depending on whether you have a will or not, different things apply. If you do have a will, generally it will go to your estate and it's distributed according to the will. If you don't have a will, it will go according to the intestacy laws, And for example, if you have a spouse, again, they're going to get everything according to the intestacy laws. So we need to actually give thought to, like, for example, if you want to quarantine funds in a joint account, you need to actually attend to some of those procedures during your lifetime.
Great, perfect timing. I got a better headshot now. Excellent. So the next, I guess, what then do people do with debts that they owe to others? So one of our questions is, if I owe someone money, a significant sum of money, how do I add that to my will?
Yeah, that's a really good question, and this is something that I would say 2 out of 3 people encounter. Because, for example, you might have a situation where you and your husband want to buy a property and you don't have money, and your brother or your mom or your uncle, someone gives you money. And we're talking about significant sum, right? Now, from a legal perspective, okay, whoever's on title has legal ownership. And I have these conversations every single day with clients. If someone's not on title, their claim, even if valid, doesn't superpass someone who's on title. So for example, if your brother gave you 1/3 of the money required to buy the house and your brother is not on title, or your mum gave you some money and your mum's not on title, unless you document legally and put restrictions on the property by way, for example, of a caveat, that person's entitlement won't hold up legally. Okay, so it's really, 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 really important. If someone has given you an amount and you have property, so they have an equitable interest in your property, that during your lifetime you seek legal advice about, how do I ensure that this person's equitable interest is protected? Is it by way of a caveat? Is it by way of a mortgage registered on the property? Is it by way of a secured loan? There's different legal interests that can be registered on a property. That's number 1. Number 2, you need to document this liability. So this is where I'm talking about, if you have the secure vault, I would be uploading copies of those loan agreements. If you don't have the secure vault, I would be keeping copies, like hard copies, with my will. So the moment I pass away, my executor gets a bundle of my assets and my liabilities. It's a no-brainer. If you have situations where someone's given you, like your dad gave you 50k cash from under his cushion back in the day, and only you and your dad know about that, which a lot of people might have those scenarios where parents might have helped them with, like, the deposit on a first home, for example. That needs to be documented, because chances are by the time you come to pass away, your dad would have already passed away, right? That loan isn't documented anywhere, and that's going to be a problem in terms of substantiating where that amount came from, where it's going to go. So excellent question. It doesn't go in your will, it goes into your assets and liabilities register. And as I said, if anyone has an equitable interest in your property because they gave you a loan, make sure you get legal advice about documenting that. Or if you've given someone money, make sure that you have a chat to them about how that's being documented, to make sure that when they pass away, you actually get your hat or your interest, and it doesn't automatically all pass through the estate.
Yeah, and this is a really good reminder to actually, if you do have an organic kind of loan agreement with people, that it's actually an Islamic requirement to write that down. So yeah. Some people write it down like it's a handwritten note with a table, dates, payments. That's sufficient, isn't it, Tasnim? And that would be considered a document that would be executed, as long as there's an executor.
I wouldn't do that for equitable interest in a property. So for example, like that situation I said where someone's, yeah. But for example, if your whole entire estate, like your mum gave you $5,000 to help you with your daughter's wedding, right? That can be documented in the format that you said, because it's sort of not insignificant. It's just, like a personal loan. I would document that and let my executor know. But if someone is giving you a loan for property, or for a house, or for an investment, or for super, or for a car, or you've given someone money for those assets, a simple written document won't do it. Seek legal advice. And the other thing is, can I just say this? A lot of people hesitate to get legal advice, whether about documenting things or whether about the estate planning. I can guarantee you the money you spend on risk managing your life right now is nothing compared to a challenge that's made on your estate or property settlement, right? For example, if we have any people that are separated in this audience right now, okay? If you've gone through property settlement proceedings in the family court, an average 2-3 year case would have cost you a few $100,000, right? Sometimes, if you just had that binding financial agreement at the beginning of your marriage, you could have avoided those costs potentially, right? Same logic and thinking that we bring to estate planning. Have those conversations, see the lawyer, make sure it's done properly, because an estate claim, the money doesn't come out of people's pocket. It actually comes out of the estate. That's the problem, because the estate has to defend the claim, right? So unfortunately, what ends up happening, people bring claims, they challenge the estate, and then the kitty that's available for distribution is all used up in legal fees, right? So if you have these arrangements, get legal advice. The 1,000, 2,000, 3,000, whatever you're paying now is nothing compared to a potential estate claim.
Fantastic. We're going to whiz through. I've got a couple that relate to public trust, and now I'm not sure if how related they are to one another. But if we circle back to a concurrent death, say mum and dad both die, and there's no will for either of them, separated or otherwise, there is a query about, public trustee who looks after the assets. Where does it go?
So that's a really, really good question. And if you're using our product, we actually have a section in our product called contingent estate distribution. What a contingent estate distribution is in the absence of anyone being able to inherit something from you, right? So, for example, you're the last remaining relative, or la samahallah, you've all concurrently died, right? Who actually receives these benefits? We have a contingent estate distribution which says, in the absence of anyone being able to inherit from me, I want it to go to XYZ. And we usually encourage people to, for example, list charitable organizations or a waqf or something like that, because that outlives people, right? Like a charity is likely to be around a few generations. So make sure that if you don't have a contingent estate distribution in your will, you do that. And subhanAllah, we've actually had a few cases that we've dealt with where Muslim estates are going back to the state because there's actually been no one to inherit them. That's in terms of if there's no one alive to inherit you. However, and I think maybe this is what the questioner may have also meant, is if me and the joint owner of the property die concurrently, right? And we still have heirs that are alive, what happens? Because we've died concurrently, okay? So from an Islamic perspective, if you die concurrently, neither of you inherits the other, right? So neither of you inherits the other. So you don't pass a share to his estate and he doesn't pass a share to your estate, so to speak. You're deemed to be non-beneficiaries to each other, and it just goes through your estate. Legally, there's differences, like under Australian law and common law, there's something that we call survivorship law. So for example, certain assets and certain laws require someone to actually outlive the deceased by 30 days to be able to receive from them, right? So for example, say me and my husband were in a car crash, then we go into hospital, I die immediately, he hangs around on life support for like a month, right? Now, Islamically, we deem death to be the moment the person actually dies. Legally, there can be survivorship mechanisms where the person might need to be alive, for example, say 30 days or what have you, right? So I can't really answer without the intricacies of that particular situation being known, because it really depends, like who died first, did you die together, do you have heirs alive, etc.
Now, what if it's only you and your children and you don't, have any option for an executor? How do you find an executor? What are some tips or suggestions for how a person might assign a executor?
Yeah, look, my number one recommendation when we're talking about executor is, who do you trust, right? So if you are in some of those, I would say like restricted family situations where, as you said, it's just like maybe just a spouse, like mum, not spouse, a parent, mum or dad and children, they're quite estranged from the rest of their family. They don't have anyone to trust, right? I would recommend seeking like a professional that you know, that you trust, that knows your affairs inside out. So whether that's an accountant or a solicitor, for example, that way you ensure that the right thing is being done by your estate, and they're aware of what's going on. The only risk to that also is they'll obviously be charging at their rates. So for example, if you've got, your spouse or your brother or your mum doing it, they're not going to charge for their time. But if they need to, for example, use a solicitor to apply for probate, that's where the money comes out. If you've got a solicitor full-time in your executor, they are going to be billing for executor duties, okay? So think about professionals if you need. The other thing is, and I didn't go through this because we just didn't have the time, you can have more than one executor appointed at the same time. We call that a multiple executorship scenario. And I would highly, highly recommend that if you have non-practicing family members, if you have non-Muslim family members, or you have a particularly complex estate, give thought to a multiple executorship scenario where you appoint more than one person to act at the same time as the executor of your estate, right? So for example, if you are a new convert to Islam, or your family is not practicing and you're the only practicing Muslim, appoint, for example, someone from your family that you trust to do the finances, and appoint a really good friend of yours that's a Muslim, right? Let them work jointly together in the management of your estate to ensure the Islamic requirements are met and the legal requirements are met. If you have a particularly complex estate, or you have children with disabilities, or you have trusts, you might appoint your husband and the accountant jointly, right? Just to ensure that your affairs are dealt with. So who should your executor be? Someone you love, trust, and can take care of things. If that's not a person, consider a professional. And if you have a complexity, consider a multiple executorship appointment.
Now, say I've got a will and I've done the right thing. I've gone ahead and created one through Muslim wills, and I've passed away then. I've nominated an executor. What's the process after my death for how contact is made with an executor?
Yep. So whether you do it through our website or whether you see a private solicitor, it's really important that you let the executor know that you've appointed them, right? It's really, really important. People just don't do this. I don't know why. How is your executor supposed to know that they're appointed if you're the one that created the document and didn't tell anyone about it, right? And that's what I said earlier about, the funeral parlors, where someone's buried, they're already 5 feet under the ground, and 3 months later, the family is looking around trying to clean up their stuff and they find the will, right? So number one, regardless of who makes your will, who you're using, let your executor know about, even if you don't want to let them know the contents of your will, let them know that they've been appointed and where they can locate the will, right? Because some people might say, I don't want the executor to know who I've left, or I might update that. You don't need to show them the will. Tell them, if I die, you're the executor and you can find my will here, okay? Now, if you're using our platform, the will document, the last page of the will document has like an encrypted passcode. So if the executor contacts us, gives us that passcode and a copy of your death certificate, we will be able to release the contents of your secure vault and your Muslim wills documents to them with that security level. But again, talk to your family, guys. Like, talk to your family, let them know what your wishes are, especially, please, if you have non-practicing family members, non-Muslim family members, if you have young children, who's going to be there for them? Who's going to actually attend to your funeral? If, for example, you have young children and you don't talk to your parents or your family members and you don't really have friends, right? So have some of these difficult conversations, give thought to it so your loved ones aren't sort of left scrummaging, at the point of your death, unfortunately.
Yeah, such an important message. Look, I think we've got time for one last question. I am conscious that we've gone over time, so thank you all so much for bearing with us and staying with us through the technical difficulties. This is actually a scenario, a real life scenario. My ex passed away shortly after our divorce settlement, which with a split joint debt. So there was a joint debt. They've gone through a divorce settlement, and that joint debt was documented in the orders. And so he's passed away, and then his will does not specify any amounts towards that joint debt. What does this person, not in a legal sense, but what are the actions then can a person take?
Yep. I would be contacting the executor of that estate and letting them know that there is this particular debt, giving them a copy of the orders, and requesting that debt is paid from the gross estate before distribution. That legally, when somebody actually passes away and you apply to the court to get the court orders to administer the estate, either through a probate, apply a grant of probate or letters of administration, there's actually a process where they publicize this person died, this is their estate, exactly for scenarios like this. In the olden days, it was like a gazette in the newspaper because people used to read the paper. Now it's actually online. So you're able to actually check at any point in time where there's been a deceased estate. So I would be contacting the solicitors, I'd be contacting the executor and letting them know about the debt, and ensuring where possible that that's recovered from the gross estate prior to distribution. The other thing this just made me think about, which is really, really important, if you have final family law orders that have made a splitting or flagging order for superannuation, those splitting or flagging orders are really, really important, because depending on what's going on for you, those orders can come into effect like 20, 30 years down the track, right? So a splitting order is the super funds are split at the time of distribution for property settlement. A flagging order is, hey, when this person receives their benefit, a particular portion needs to go to this person, right? So if you have a flagging order pursuant to final family law orders or consent order, you need to give thought to how that sits with your estate planning and your binding death nominations, because is there or isn't there going to even be an interest coming out of your super, right? The other thing is, if you're separated but not divorced, right, make sure that you update your binding death nominations to ensure that these scenarios don't happen where a person continues to be receiving a benefit or potentially eligible to receive a benefit when they shouldn't be, right? So what we'll do, inshallah, is we'll develop a fact sheet that we will send around after this seminar to those who attended. So we'll give you sort of the heads up about these things. But at a macro level, people really need to give thought to a few things. Number one, make a will if you haven't made one. Use our platform. It takes the guesswork out of it for you. And if you can't use our platform because you have a complex estate or you're seeing your own solicitor, for example, make sure that what we covered today is dealt with in your will, right? That's number one. Number two, if you already have a will, please, and you've been separated, or you didn't attend to the Wasiyyah section, or you didn't put the Islamic fara'id in, or whatever, like there was an issue with the will, please revisit the will. So number one, make a will. Number two, if you have a will, revisit the will. Number three, revisit your superannuation nominations, regardless of all of the above, because you need to make sure that they're current, okay? So they're current to who you want it to go to. And if you want your super to come into your estate, you need to make your estate the beneficiary of your super. So everyone needs to review their super. I didn't mention this, but since we're on the topic of super, if you have a self-managed super fund, a self-managed super fund is a trust structure, and the deed of your self-managed super fund actually states where the benefits are to go upon winding up or upon death of the beneficiaries, right? So if you have a self-managed super fund, please check your deed. Most people don't even remember they had the deed because their accountant made it whenever they established the trust, right? So please, super, that's number three. Number four is children's nominations, right? Think about who you want to take care of your children. Where possible, talk to the other biological parent. Have the same nomination to prevent issues in the event that you pass away or you and the other parent concurrently pass away. That's number four. And then number five is give thought to your